Good morning, everyone. Before we start this moot court simulation, let us introduce ourselves.
My name is Alya Emaliana as a judge.
My name is Annisa Al-Kubraa as a judge.
My name is Nugrahantono as a judge.
My name is Tasya Noviutami as a delegate from Bosnia.
My name is Ivano as delegate from Bosnia.
My name is Erika Belita Vinky as delegate from Bosnia.
My name is Fina Puspita as delegate for Bosnia.
My name is Ghatfhan Hanif as delegate from Serbia.
My name is Raditya as delegate of Serbia.
My name is Putriana Oktanadia as delegate from Serbia.
Ladies and gentlemen, the court meets today is to deliver judgment in the case concerning the application of the International Convention for application of the Convention on the Prevention and Punishment of the Crime of Genocide between Bosnia and Serbia.
In 1992, war broke out between Serbia and Bosnia because of the atrocities and ethnic cleansing by the sub-soldiers. There was a massacre of more than 8,000 ethnic Bosniak men and teenagers on July 1995 in the Srebrenica area, Bosnia, by the force of the Srpska Republic led by General Ratko Mladic. On 20 March 1993, the Republic of Bosnia and Herzegovina instituted proceedings against the Federal Republic of Yugoslavia in respect of a dispute concerning alleged violations of the Convention on the Prevention and Punishment of the Crime of Genocide, adopted by the General Assembly of the United Nations on 9 December 1948, as well as various matters which Bosnia and Herzegovina claimed were connected therewith. On 20 March 1993, following the submission of its application, Bosnia and Herzegovina filed a request for indication of interim action under Article 41 of the statute. And on 1 April 1993, Yugoslavia submitted written observations of the request for Bosnia and Herzegovina for interim measure.
Each of the parties do file a memorial within the time limits fixed by the court. Having regard to the provision of the special agreement concerning written pleadings, the special agreement provided for the possible filing of court pleading by each of the parties. To the delegate of Bosnia, I welcome you to state your argument.
Thank you, Your Honor. We are here as a delegate of Bosnia are going to give our statement. The act of which shocked the conscience of mankind. This part of the memorial deals with the interpretation, application, and effect of the Genocide Convention 1948 Convention to the act of the Serbia force. Here below example of the following categories of acts committed by Serbia force, mainly but not exclusively direct against the Muslim population of Bosnia Herzegovina are referred to. Section 1, the use of concentration camp. Section 2, killing. Section 3, torture. Section 4, rape. Section 5, expelling of people of destruction of property, home, place of worship, and cultural object. Section 6, the creation of destructive living conditions, selling, starvation, and intimidation of the population. Section 1, concentration camp. From early 1992 onwards, the Serbia force extensively use concentration camp with which they carried out multiple killing, rapes, torture, and starvation, predominantly against Muslim Bosnians. At least 170 of such camps were identified, in which tens of thousands of Bosnian, mainly Muslims, are imprisoned. In all these and other camps, Bosnian people were treated in a manner which is so shocking as to almost defy description. The scam and the others which were operated by the Serbian force served one purpose: destroy the life, will, dignity, and existence of the Muslim people of Bosnia and Herzegovina. The systematic nature in which the Muslim victims were apprehended after Serbia forced took control of the particular area, and their subsequent statement point to specific policy to achieve their destruction. Section 2: Killings. The destruction of mainly Muslim life is naturally part of the military and ethnocentric strategy of the Serbia force. The scale in which this took place and is still taking place is such that an estimated quarter of million Muslim in Bosnia and Herzegovina have become its deadly victims. At the beginning of April 1992, more than 100 Muslim civilians are killed by Serbia paramilitary military force in Vildina. Report to the United Nations submitted by the Permanent Representative of Canada. During one particular incident on 12 April 1993, at least 15 children were killed whilst playing football in a schoolyard, with a 6-year-old boy being instantly decapitated.
Sections 3. Tortures. Starvation, humiliation, sexual assault including rape and buggery, physical violence, and psychological attack against mainly Muslim but also Kurds were all too common in areas where Serb forces had control. The concentration camps were not the only scene of such calculated barbarity. Hospitals were also used as torture camps by the Serb force. Muslim survivors of an early massacre by Serb forces at Vlasica were interned in the Paprikovic Optical Hospital on the outskirts of Banja Luka, which was being used at the time by Serb forces in the region. Section 4. Rape. The depths of depravity to which the Serb force plunged in their desire for an ethnically pure. Serbs are involved the rape of girls as young as 7 and women as old as 70. Amnesty International in its report Bosnia-Herzegovina rape and sexual abuse by armed forces that January 1993 referred to some incident of rape. At page 12, details of the account of a 7-year-old rape victims are given. She was taken by Serb wearing DNA uniforms and held for 3 months together with around 100 women. During her detention, she and the other were repeatedly raped and told that they would bear Serbian children. Section 5. Expelling of people and destructions of property. The strategy of Serb forces not only involved direct violence to Muslims and also Kurds. Rather, it was often preceded by severe selling of a town or village, the indiscriminate killing and devastations being designed to cause maximum destructions, such that people were forced to leaving their home. Upon doing so, threats of Muslim and also Kurds presence in the form of churches and mosques were obliged treated. If lucky, the fleeing population escaped with their lives. More often, they encountered the surface and were intimidated, imprisoned, raped, tortured, or killed by them. The use of such a clinical term as ethnic cleansing to describe such intense brutality and inhumanity serves to demonstrate the depravity of the search force, their complete disregard for human life, liberty, and the values which underpin all forms of civilized behavior.
Section 6. The creation of destructive living conditions. In their desire to create ethnically pure Serbian areas and to realize their nationalistic and territorial ambitions, the Serb force used TV, radio, and newspaper extensively to vilify Muslims and Croats. This in turn resulted in atmosphere in which hatred initially led to discrimination in many areas including employment. Inevitably, this turned to violence against Muslims and Croats. Assertions of law. This legal relevance of the pronouncement of United Nations organs. The United Nations Commissions on Human Rights and its subcommissions and special reporter, the Human Rights Committee and Vienna Conference on Human Rights, all of which were also undoubtedly competent in this sense of Article 8 of the Genocide Convention. 2. Statute of International Tribunal established by the Security Council specifically include the Genocide Convention and the concept of crimes against humanity as sources of law with respect to the situations in the former Yugoslavia. The General Assembly, as early as 25 August 1992, when adopting resolutions 461,242, strongly condemned the aberrant practice of ethnic cleansing, which in its view constituted as grave and serious violation of international humanitarian law. At its first special session, the Commission on Human Rights appointed a special reporter, Mr. Tadeusz Mazowick. The special reporter described the means of ethnic cleansing in detail, including the bombardment of civilian targets, of mosques, the systemic starvation of populations, arbitrary detention and executions, and the continue. He placed emphasis on the selling of population centers and the cutting off of supplies of food and other essential goods, referring to the most dramatic and well-known case of Sarajevo, which had it to the belief of some that the attacking forces and determined to kill the city itself. Many submissions to the United Nations Commissions of Experts and the United Nations Security Councils also reflect the genocidal characters of even in the Republic of Bosnia and Herzegovina. The submissions of United States, for example, cover acts of willful killing, torture of prisoners, abuse of civilians in detention centers, deliberate attacks on non-combatants, and mass forcible expulsion and deportations. This type of acts taken as individual categories and its their totality fall securely within the definition of genocide provided in Article 2 of the Genocide Convention. This has been clearly confirmed by authoritative and objective international organs, reflecting views of the vast majority of states.
Prayers for relief. On the basis of the evidence and legal arguments presented above in the memorial, The Republic of Bosnia and Herzegovina requests the International Court of Justice to adjudge and declare the following. First, that the Federal Republic of Yugoslavia, including Serbia and Montenegro, directly or through the use of its surrogates, has violated and is violating the Convention on the Prevention and Punishment of the Crime of Genocide by destroying in part and attempting to destroy in whole national, ethnic, or religious group within the, but not limited to the territory of the Republic of Bosnia and Herzegovina, including in particular the Muslim population. Number two, that the Federal Republic of Yugoslavia has violated and is violating the Convention on the Prevention and Punishment of the Crime of Genocide by conspiring to commit genocide, by complicity in genocide, by attempting to commit genocide, and by incitement to commit genocide. 3. That the Federal Republic of Yugoslavia has violated and is violating the Convention on the Prevention and Punishment of the Crime of Genocide by aiding and abetting individuals and groups engaged in acts of genocide. 4. That the Federal Republic of Yugoslavia has violated and is violating the Convention and the Prevention and Punishment of the Crime of Genocide by virtue of having failed to prevent and to punish acts of genocide. 5. That the Federal Republic of Yugoslavia must immediately cease the above conduct to take immediate and effective steps to ensure full compliance with its obligation under the Convention of the Prevention and Punishment of the Crime of Genocide. 6. That the Federal Republic of Yugoslavia must wipe out the consequences of its international wrongful acts and must restore the situations existing before the violations of the Convention on the Prevention and Punishment of the Crime of Genocide were committed. 7. That, as a result of the international responsibility incurred of the above violation of the Convention on the Prevention and Punishment of the Crime of Genocide, the Federal Republic of Yugoslavia is required to pay, and the Republic of Bosnia and Herzegovina is entitled to receive, in its own right and as a parens patriae for its citizen, full compensation for the damages and losses caused, in the amount to be determined by court and a subsequent phase of the proceeding in this case. That ends the statement and memorial by the Bosnia and Herzegovina point of view. We give back the floor back to you, Your Honor. Thank you.
Okay, thank you to the delegation of Bosnia for your statement. Now we are going to hear the statement from the delegation of Serbia. Please state your argument.
Thank you, Your Honor. We are a delegate from Serbia. We are going to state the facts. The events in other parts of the Socialist Federal Republic of Yugoslavia certainly had some influence on those developments, as well as the support of secession by some international factors. The violent succession of Slovenia, the armed revolt in the Republic of Croatia, and attacks on the JNA and the Serb population in that republic, and the civil war in that republic certainly influenced the political position of the Serb people. The basic cause of the negative developments in the former Yugoslav Republic of Bosnia and Herzegovina is the disagreement between the three main ethnic groups or the political parties which represented them about the succession from the common state, the Socialist Federal Republic of Yugoslavia. This disagreement culminated in armed conflict and civil war and the creation of several separate states in the region. The applicant makes a series of assertions against the respondent which are not founded on facts. In paragraph 6.3.2.7 of the memorial, the applicant denies that the Republic of, of Srpska is a state. It says that it has a territory and population, but it has neither an organized political authority nor sovereignty in the meaning these words have in international law.
Okay, the facts are related to the founding of the Republic of Srpska. And then I the representation of this argument. The first is the first multi-party elections in the Socialist Republic of Bosnia-Herzegovina were held on 18 and 19 November 1990. The results were published in the official gazettes of SR Bosnia. The number is 42 11 990, date 19 December 1990. The first is the electoral results clearly demonstrate the political positions of the citizens of the former Yugoslav Republic of Bosnia-Herzegovina. It's clear that the overwhelming majority of citizens vote according to the national affiliation for parties that represented their national interests. In a letter to U.S. Secretary of State James Baker, the SDS said that it had won the support of three-quarters of the Serb people in Bosnia who wished to live in federal Yugoslavia, in which parts of the Serb people wouldn't be national minorities. And then after it became obvious that the Muslims and the Croats in Bosnia didn't wish to remain in Yugoslavia, Dr. Karadzic told a press conference held in Belgrade on 18 July 1991 that each people could leave Yugoslavia but without harming other peoples that wanted to remain in Yugoslavia. Serbian and English versions of a brochure entitled What the Serbs Purpose were distributed at this press conference. The purpose of this brochure was to accurately present the position of the SDS and thus oppose anti-Serb propaganda. And finally, on 22 December 1991, the SDS proposed a comprehensive democratic transformation of Bosnia into a confederation of three ethnic communities with three parliaments. However, radical Muslim groups hindered these efforts with their persistent attacks on the Muslim Bosnia organization. Then the representative of the Muslim Bosnia organization were exposed to great pressure and open threats by radical Muslim groups in SDI, which prevented the conclusion of the agreement. Unfortunately, it seems that the Serbs in Bosnia and Herzegovina had good reasons to believe that the Muslim Party of Democratic Action intended to use the opportunity created by the secessions of Slovenia and Croatia from the SFRA to transform of the Bosnian civil society into a religious Islamic society. The Muslim leaders whose old dream was the introduction of their Islamic style of life in Bosnia and Herzegovina came to power in Bosnia and Herzegovina. And then the political religious program of the said group was prepared by Alija Izetbegovic and entitled the Islamic Declaration. It was illegally published and distributed among the Muslims in Bosnia and Herzegovina in 1920. Thank you.
Assertions of law. Punishable acts are defined in Article 3 of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, as follows. The following acts shall be punishable: A. Genocide. B. Conspiracy to commit genocide. C. Direct and public incitement to commit genocide. D. Attempt to commit genocide. And E. Complicity in genocide. Acts preparatory to genocide do not fall within punishable acts. Preparatory acts taken for the purpose of committing genocide do not fall within punishable acts. 1. Forced displacement, i.e., ethnic cleansing is not genocide. Such acts are certainly not allowed and are grave breach of humanitarian law, but they do not constitute genocide. In several places, the applicant itself notes that these acts have been committed with the intent of expelling the population away from a given territory. Such intent is not legitimate or legal, but it is not an element of the definition of genocide. Only the intent to destroy a group invests the acts with a genocidal character. The displacement of members of a group by force is not included in the acts prohibited under the Genocide Convention. 2. Acts not directed exclusively against members of a group do not constitute genocide. Acts committed against a group composed of members of a number of protected groups do not constitute genocide if the perpetrator of the act cannot direct its effect against the member of one group only. Thus, the bombing of settlements inhabited by members of different ethnic and religious groups or the holding of such settlements under siege do not constitute genocide. 3. Article 4 of the 1948 Convention on the Prevention and Punishment of the Crime of Genocide envisaged that only physical persons are subject to punishment for the commission of genocide or another punishable act enumerated in Article 3. So, according to the 1948 Genocide Convention, a state cannot commit genocide and other punishable acts.
As for the prayers for relief, we, the Federal Republic of Yugoslavia, request the International Court of Justice to adjust and declare 1. In view of the fact that no obligation established by the 1948 Convention on the Prevention and Punishment of the Crime of Genocide have been violated with regard to Muslims and Croats. 2. In view of the fact that the acts alleged by the applicant in its submission cannot be attributed to the Federal Republic of Yugoslavia. Third, Bosnia and Herzegovina is responsible for the acts of genocide committed against the Serbs in Bosnia and Herzegovina and for other violation of the obligation established by the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. 4. Bosnia and Herzegovina has the obligation to punish the persons held responsible for the acts of genocide and other acts prohibited by the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. 5. Bosnia and Herzegovina is bound to take necessary measures so that the said acts would not be repeated in the future. 6. Bosnia and Herzegovina is bound to eliminate all consequences of the violation of the obligation established by the 1948 Convention on the Prevention and Punishment of the Crime of Genocide and provide adequate compensation. That's for the memorial of Serbia, and we like to give it back to the judge.
Thank you for statement from you both. Now that we have heard all the statements given from delegates from Bosnia and Serbia, I'm going to state the verdict. The court found that Srebrenica killing in July 1995 were carried out with the specific purpose of destroying several Bosnian Muslim groups in the area, and that what happened there was genocide. The court found corroborating evidence that the decision to kill the adult male population of the Muslim community in Srebrenica was taken by several members of the VRS main staff. However, the evidence before the court did not prove that the VRS action could be linked to the response then based on international legal rules regarding state responsibility. Despite this, the court ruled that the Republic of Serbia had breached its obligation under Article 1 of the Genocide Convention to prevent Srebrenica genocide.
The court stated that the respondent has violated its obligation to punish the perpetrators of genocide, including failing to cooperate fully with the International Criminal Court for the former Yugoslavia in connection with the submission of general recommendation. This failure constitutes a violation of the respondent duties under Article 6 of the Genocide Convention. Regarding the obligation of prosecute act of genocide, the court ruled that the declaration in the operating clause that Serbia had violated its obligation under the convention and that Serbia should transfer individuals accused of genocide to the International Criminal Court for the former Yugoslavia and must cooperate fully with the court.
So, that's all for today. Thank you everyone for your attention. I declare the sitting is closed.